Hello, everyone. Thank you so much for joining us. We'll get ahead and get started in a few minutes. I'm gonna let some more folks trickle in. Thank you for joining us for part one of the Fair Housing and Tenant Rights training. This training will be an overview of tenant rights. We are very lucky to have Sarah, Darlene, Anna, and Laura from Bay Area Legal Aid with us today. And so we're just gonna give a couple of more seconds and then we'll get started. Alrighty. To introduce myself, my name is Sadaka. I'm a policy analyst at Homebase. Homebase is a nonprofit technical assistance provider. We provide TA for COCs across the nation. We work closely with the Office of Supportive Housing in Santa Clara County. One of the many things we do is put on trainings on behalf of OSH, including the Fair Housing and Tenant Rights Training Series. Today, we're focusing on part one of this series, which will cover tenants' rights. Just to let you all know, Day 2 is going to cover fair housing on Thursday, April 18th, 2024, same time. And Day 3 is going to cover eviction overview on Thursday, April 25th, 2024, same time. In terms of tech, I know you're familiar with Zoom by now, but I do want to let you know that we are recording this training because, as always, all the training materials will be sent out and be posted on the COC training website, so don't feel like you have to screenshot the slides. We're going to keep everyone on mute by default, but there will be questions at the end for you to unmute yourself. In the meantime, please ask questions in the chat. Laura, Anna, Darlene, and Sarah will all be monitoring, helping answer questions in the chat, as well as myself. If you have tech issues, please chat me directly so I can try to help you. If you get kicked out of Zoom completely or otherwise unable to chat me, please send me an email at sadaka@homebaseccc.org. Closed captions are available, so if you hit closed captioning, you should be able to see them. And just for a little quick icebreaker, and an introduction so that you're all familiarized with the chat, we're going to ask you to introduce yourself in the chat with your name, your organization, and what could you teach a class on. I will put in the chat an example. Now I'm going to switch over to Bay Area Legal Aid slides. Give me a second. Can everyone see my screen now? Perfect. Now I will let folks from Bay Area Legal Aid introduce themselves and start the training.
Good morning, everybody. Thanks for the introduction, Sadaka. Like we mentioned, this is the start of our three-part fair housing and tenant rights training series. We'll start by introducing ourselves. The presenters will introduce themselves, and then we'll jump into it. As you'll see when we get to our agenda, we have a very packed schedule, as we will for the next 3 weeks. So if we talk quickly and you have questions, please feel free to raise a hand, unmute, put it in the chat, and we'll try and address questions as we go. But we will leave time at the end for questions. It's a lot of material. So again, if we talk fast and you want us to slow down and expand on anything, just let us know as we go. Why is it? I'll start with introducing myself. My name is Sarah. I'm an attorney at Bay Area Legal Aid in our housing unit, and I'll pass it to Anna.
My name is Anna. I'm a staff attorney at our Santa Clara housing unit, and I've been here for about 3 years, and I'll pass it to Darlene. I don't know why I added that.
Hi, thanks, Anna. Hi, good morning, everyone. I'm Darlene Williamson, and I'm a staff attorney in our housing unit here in Santa Clara, and I'll pass it to Laura.
Hi, good morning, everyone. My name is Laura Bearer. I'm the supervising attorney for housing unit in Santa Clara County at Bay Area Legal Aid. I will be monitoring the chat and trying to answer any questions. So if you have any questions, please feel free to put them in the chat. Thanks.
I'm ready for next slide. Okay, so we'll start with our agenda for our 3-part series. Again, as you can see, it's a lot of material. So today we're going to give an overview of tenant rights. So we'll talk about rental applications and screenings, criminal history information, a lot of information about security deposits, habitability issues that tenants might face, best practices for both tenants and landlords. We'll go into an overview about rights related to survivors. So this is the Violence Against Women's Act, and then the Tenant Protection Act, which is our statewide California Tenant Protection Act. For next week, we will do an overview of fair housing protections, and then our final part of the series will be an eviction process overview. So if you have questions about our part 2 or part 3, please save those questions for those weeks and save your questions today for our tenant rights material. Next slide. Okay, and this is again our agenda for today. Kind of a little bit of a duplicate slide, so we can go to the next slide.
Bay Area Legal Aid provides free legal services to eligible low-income residents in the Bay Area. We serve Alameda, Contra Costa, Marin, Napa, SF, San Mateo, and Santa Clara. And we're going to just talk a little bit about the Santa Clara County office's specific practice areas.
We have 8 main practice areas in Santa Clara County, and first and foremost, our Housing Preservation and Homelessness Prevention Unit. Our attorneys handle landlord-tenant matters, eviction defense, fair housing and discrimination issues, and subsidized housing issues. We also have an immigration unit that provides services to survivors of domestic violence, and they include VAWA self-petitions and U visa petitions, temporary restraining orders, and other services for survivors in conjunction with domestic violence prevention practice. And we also have a health consumer center, which assists clients with navigating services from public and private health insurance programs, such as Medi-Cal, Medicare, and in-home supportive services, plus other county health-based programs.
Darlene already alluded to our DV and sexual assault prevention practice, where we assist with obtaining TROs, divorces, child and spousal support orders, and safe custody and visitation orders. We have an economic justice unit where we help clients get access to or address wrongful terminations of income support programs like SSI, SSDI, general assistance, food stamps, CalWorks, etc. We have a consumer law practice that handles fair credit reporting issues, fair debt collection practices, bankruptcy counseling, and related advice. And then finally, we have a youth justice practice that assists people in or regarding foster care, youth healthcare access, Social Security income, education, housing, and homeless youth services. Next slide.
Okay, we have a big group here today, and I think most of you are service providers, but if you are, referring people to Bay Area Legal Aid, or maybe you have come to us in the past, we're just going to give an overview of what clients are eligible for our services. So our three main areas are residency, citizenship, and income. So to be eligible for our services, we need clients to be living in one of our Bay Area counties. So this is Alameda, Contra Costa, Napa, Marin, Santa Clara, San Francisco, or San Mateo. So we have a lot. Our citizenship requirements are clients need to be US citizens or an eligible immigrant. To be an eligible immigrant, this includes people who have an application for permanent residency pending, are permanent residents, refugees, asylees, or any immigrant who has been the victim of domestic violence, sexual assault, human trafficking, or other violent crime. So there are a lot of exceptions to the citizenship requirement. And if you have a client that you are unsure if you should refer to our office, please just have them call our legal advice line to get screened. But these are kind of general guidelines. And then finally, our income requirement. Generally, a client's income needs to be under 200% of the federal poverty line. The exception to this is our Health Consumer Center hotline. There is no income requirement for that. But also we have a lot of different grants that have varying income levels. So just like with the citizenship requirement, if you have a client who you're not sure if they qualify, please just have them call our hotline and they can get screened. Next slide.
People who want advice, potential clients, can reach us by calling our legal advice line. The number and the hours are here on the slide. Or if it's a healthcare issue, they can call our Health Consumer Center line, which is separate and open more hours.
No.
Sorry. Oh, I think someone unmuted by accident. Okay, next slide.
Okay, without further ado, we're going to jump into our first topic of today, which is tenants' rights. Next slide, please. And we'll start off with rental applications and screening from the beginning. Generally, landlords can require certain information from a potential tenant to screen them to see if they're going to be a good tenant. And often the applications will include names and contact information for current and past landlords, past and current employment, and other references. Landlords also may require applicants to provide a screening to cover the cost, a screening fee to cover the cost of obtaining a credit report. And each landlord is different. There'll be different qualifications depending on, sometimes it's a smaller, more mom and pop landlord versus a larger company as far as the application requirements and screenings. Some landlords are very lenient with the information, and then some are very stringent. In terms of the fee that's required, the fee is around $50. And the landlord, if a landlord does a screening and gets information from that screening, they have to abide by fair housing laws in regards to the Fair Credit Reporting Act and being able to provide information if there's negative information in that report. If a application is denied for a tenancy, they need to be able to pass that information along to the tenant. So that is a important thing for tenants to know, just to make sure their rights are protected. Landlords may choose to accept a tenant or not, depending on their credit score. That's a big issue, as well as if they've had a prior eviction. Now, another thing that a tenant may offer and a landlord may consider is in lieu of a credit score that is less than desirable, they may be able to provide additional information to show that they've been able to pay a rental history in the past, and be able to provide that information to a landlord for consideration in their application. Next slide. Another factor that a landlord can consider in terms of a tenant's application is their criminal history. And the main reason for this is just to make sure that the landlord can maintain safe premises for those that are occupying the premises. However, there are certain types of criminal histories that are excluded and cannot be included for determination in a tenant's application. And that's criminal history that involves an arrest that did not lead to a conviction, participation in a pretrial or post-trial diversion program, any record of conviction that has been sealed by the court, or a conviction that came from the juvenile justice system. There's also regulations that prohibit landlords from having blanket bans, which is a general ban on all applications with any criminal history, in particular, or even, not allowing anyone with, all felonies are excluded. The landlords really need to look at the individual circumstances of an applicant involving any past conviction as to whether it's directly related to their ability to be a good tenant. Next slide, please. Here's a long list. It's criminal histories that a housing provider may not consider in terms of the application. Accessing criminal or civil records older than 7 years. Asking for or using information about arrests that were not leading to convictions. Again, having a blanket no felony policy or otherwise excluding all individuals with any criminal record. They cannot ask or use information about juvenile adjudications or information about convictions that have been expunged. They can't deny someone on the basis of convictions or other criminal records that were a function of disability, and we look at reasonable accommodations for that. Or deny anyone on the basis of convictions or criminal records that are related to domestic violence. Specifically, look at your VAWA statutes for federal subsidized housing, otherwise potentially discriminatory information under the fair housing laws. Just wanted to give an example in looking at someone that has a felony record. One example would be someone who had a prior record for a concerning, felony, but the circumstances and years that passed since that felony and other circumstances, an individual who has significantly aged. There was a case that had someone who was rendered a paraplegic. They did not have the physical capacity to, involve any violence or things like that that had happened previously in the past. And so really taking a look at the individual circumstances and not just the conviction record alone is what landlords are required to do in making a determination. Next slide, please. Again, housing providers can obtain third-party information regarding both consumer reports and criminal history information. And again, that is subject to the Fair Credit Reporting Act, and a landlord must notify the applicant for a potential tenancy if they make an adverse decision based partly or completely on that third-party information and criminal history that they find. Okay, next slide. And we're going to break things up a bit. We have a couple of hypothetical questions just to kind of review the information that we've discussed so far. We just have question number 1. A landlord posts an advertisement for an available 1-bedroom unit. The advertisement specifically states no individuals with criminal records. Is this permissible? Yes or no? And there's a poll on your screen where you can put in your answer. And we've got question 2 up there as well. And we have answers coming in for that as well. The landlord posts an advertisement with an available 1-bedroom unit, specifically stating no individuals with prior felonies. Permissible, yes or no? Right, we've got answers coming in. And thank you to everyone who's responding to the poll. We have a few more scrolls coming in on question number 2. And overwhelmingly, the majority of you answered no to both questions 1 and 2. And the answers are correct there. Those answers are no for both questions 1 and 2. Those would be blanket policies regarding criminal history that are not permitted. And I don't know if you want to share the results of the poll, but we're ready to head on to the next section and our next slide, which would be regarding security deposits. And I'll turn it over to Sarah.
Again, everybody had a chance to read through the chat while Darlene was speaking. It was great to hear what folks would teach with their expertise. So we'll move on to security deposits. I think this is something that everyone has had some kind of experience with. I think probably almost all of us have been a tenant at one time in our life. So currently, the law is that a landlord may charge up to 2 months of rent for a security deposit in an unfurnished unit, or up to 3 times the monthly rent for a furnished unit. So quite a bit of money that could be asked to pay upfront as you move into a new apartment. There's a new law around security deposits that will go into effect this July, so in a few months, that will change the amount a landlord can request in a security deposit. So now, starting in July, a landlord can only require 1 month's rent for an unfurnished or furnished apartment. So quite a significant change for folks who have rent, $3,000+ $2,000, whatever it may be. There's an exception to this, like there is for any law, unfortunately. If you have, essentially it's targeting smaller landlords, so mom and pop landlords. If you have a landlord who is a natural person, so not a business, or an LLC comprising of all natural persons, and that landlord owns 2 or less properties that collectively include less than 4 units, and the tenant is not a service member, then your landlord can still charge 2 months rent for a security deposit. So again, this allowing 2-month exception is only if you meet 1, 2, 3 categories here on the screen. So in general, if you're at a big apartment complex, you are only going to be allowed to pay 1 month's rent for a security deposit. So a good change. Next slide, please. Okay, returning security deposits. This is a big issue for, again, anyone who's been a tenant and leaves their apartment after their lease is up and wants to get their security deposit back. So a landlord has to return a security deposit within 21 days of you leaving your apartment, either in full or by giving you an itemized list of what they used it on, including receipts. If your landlord does use any of your security deposit, they have to give you this itemized list of deductions with receipts. And if they don't, they're not following the law. Things that are covered under lawful deductions are things like costs for repairs beyond normal wear and tear. They can use it for unpaid rent. They can use it for cleaning fees. If your landlord does not properly return your security deposit or uses it for things that you think are improper, you can send a demand letter to your landlord saying, I think this was improper. And if they don't comply with your demand letter, you can then sue them. And typically, because of the amount of security deposits, these lawsuits happen in small claims. Okay, next slide, please. Habitability. So switching gears a little bit. Habitability is essentially any unit, apartment that you live in. It needs to be kept up to a certain standard. So your unit needs to be livable. It needs to be habitable. And the law spells out what a habitable unit means. So I'm going to go through a lot of specifics. It's a lot of information to take in. So again, feel free to stop us and ask questions if you have questions along the way. So a landlord has a legal duty to provide you as a tenant with a habitable unit. What makes a unit habitable is things like effective waterproofing and weather protection. This includes the roof, exterior walls, things like unbroken windows and doors. The plumbing needs to be in good working order, hot and cold running water, connected to a sewage disposal system. The gas facilities need to be in good working order, heating facilities, good working order. Electrical system needs to be working, lighting, wiring, equipment. You get the picture, everything in good working order. The unit themselves, the building themselves needs to be clean and sanitary. The grounds, not just the unit itself, but the whole property needs to be clean and sanitary, free from debris, filth, rubbish, garbage, rodents, vermin. There needs to be adequate trash receptacles, floors, stairways, railings, all in good repair. There needs to be in each rental unit a working toilet, wash bin, bathtub, or shower. The toilet, bathtub, or shower needs to be in a room that's ventilated and allows for privacy. The kitchen needs to have a sink that is not made from absorbent materials such as wood. There needs to be natural lighting in every room. This can be through windows or a skylight. The windows in each room need to be able to be opened at least halfway for ventilation, unless there's some kind of fan or other ventilation system. There needs to be safe fire exits or emergency exits leading to a street or a hallway. The stairs, hallways, and exits all need to be kept litter-free. Storage areas, garages, basements also need to be kept free of combustible materials. There needs to be operable deadbolt locks on the main entry doors of your rental unit and operable locking or security devices on your windows. There needs to be working smoke detectors in all units of multi-unit buildings. This could be things like duplexes or apartment complexes. Apartment complexes also need to have smoke detectors in common stairwells. And then your mailbox needs to be able to lock. And the mailbox also needs to be consistent with USPS standards for apartment housing mailboxes. So you can see that was a very long list of things that a landlord needs to do to keep your unit habitable. And a lot of times, especially folks that work in housing, we see units that do not have all of these requirements. So it's very possible that you will have clients or tenants who do not have a completely habitable unit. And we'll talk later in this presentation about what to do if you have a client who lives in a unit that has habitability issues. Next slide. So what should a tenant do if repairs are needed or the unit becomes uninhabitable? So what a tenant should do is notify their landlord immediately. A landlord conceivably does not know of a problem unless they've been told. And as we'll talk about later, the tenant does have that obligation to tell a landlord, hopefully in writing, when something is wrong. It's not required, sometimes it is, but let's say it's not required that things are in writing, but it is always best practice to keep a record of any time you've told your landlord that something's wrong. Best would be a letter, an email, even a text, some kind of written record so that you can look back and say, no, I did notify my landlord on this day and they never responded. So what if a tenant substantially caused the unlivable condition, which does happen? So if a tenant is the one that caused the issues, they are responsible for the repair costs. A tenant also may be responsible for costs if they substantially interfere with a landlord trying to conduct repairs. This can look like if a tenant is illegally not allowing the landlord to come into the unit to fix things or not allowing repair work to be done. Okay, what are a tenant's remedies if they properly notify their landlord of a problem, but the landlord refused to conduct repairs, which we do see a lot? You can see there's a list of about 5 different things here. I'm going to go through each one. It's a lot of information, but some of these things we don't recommend. So even though it is an option for a tenant to do, I'm going to explain why some of these things are not recommended on the legal side for a tenant to do if their landlord is not making repairs. So the first thing on our list is contact code enforcement. So if repairs are required and the landlord has not fixed them, then a tenant, after giving reasonable notice to their landlord, reasonable time for them to fix things, if it's just not happening, a tenant can contact code enforcement. Code enforcement is a government agency that can conduct investigations and mandate that the landlord complete these repairs. There is a risk to calling code enforcement. So if the habitability issues in the unit are really severe, there's a risk that code enforcement could red tag the unit or essentially say it's so unlivable, that everyone needs to leave. And so even though things needed to be fixed, you now might have a tenant who is forced to leave their home and maybe has nowhere else to go, even if the place they were living was so uninhabitable. So the risk there is that, yes, the problems would get fixed or the landlord would be held accountable, but the tenant might be forced to leave. In this situation, it's possible a landlord could provide relocation assistance. However, in practice, sometimes this leads to the tenant having to sue the landlord for that money. A lot of times landlords aren't just offering up money for tenants to move, even if it's legally required. Our next method or next remedy for a tenant is called repair and deduct. So this is a legal remedy that a tenant has, but often it's not used properly, and so that is why we do not recommend it. So this is essentially where a tenant makes the repairs themselves and then deducts the cost of that repair from their rent. The reason we don't recommend this is that in the law, there are specific steps a tenant has to take to use this remedy, and the habitability issues have to rise to a certain level before this right kicks in. And it's hard to tell whether or not the habitability issues are severe enough that you can use this method. So again, it's a risk to do this. This remedy covers substandard conditions that affects the tenant's health and safety and that substantially breach the implied warranty of habitability. So legal terms, that essentially means the habitability issues need to be pretty bad. A tenant can only use this remedy twice in a 12-month period. And the repairs that need to be done can't be caused by the tenant, anyone in their household, their guests, or their pets. Before using this method, a tenant needs to inform their landlord, preferably in writing, of the repairs that are needed. They then have to give the landlord a reasonable time to fix it. Reasonable will vary, but usually maybe like 30 days is a kind of general example. If it's something more severe, like your heater is broken in the winter, obviously at reasonable time could look something like a day or two. If the landlord does not conduct these repairs in whatever a reasonable time would be, then the tenant could conceivably repair the issues themselves and deduct that money from the rent. What we see in practice is that even if the tenant has done every step of this correctly, if they don't pay their full rent, their landlord gives them a 3-day notice to pay or quit, and then you're dealing with a potential eviction proceeding. And even though you could have this defense of, I followed the law, I did repair and deduct, you still are putting yourself at risk of an eviction proceeding. The next remedy is abandonment. So instead of using repair and deduct, a tenant might simply abandon the unit if the habitability issues are so bad. Similar to repair and deduct, to use this remedy, the habitability issues need to be directly related to the tenant's health and safety. It can't be caused by, again, the tenant, their household, their guests, their pets. They need to inform the landlord of the issues in writing. They need to give that reasonable time for the landlord to fix. And then if no repairs were made, a tenant could abandon the unit, meaning break their lease and potentially not be responsible for whatever rent is remaining on the lease or the damages a landlord might receive trying to get a new tenant. Same as the prior, the risks here are maybe the habitability issues aren't severe enough for this remedy to kick in. A landlord could still sue the tenant for those lost rent, damages, etc. And now the tenant is on the defensive, having to say, no, this remedy was appropriate. Our fourth option here is just to withhold rent. So not fixing the problem, but just withholding the rent until the landlord fixes things. You can see a theme here. This is also not recommended. Anytime you're withholding rent, you put yourself or your tenant at risk of receiving a 3-day notice / eviction from a landlord. In situations where you have a tenant who is withholding rent, we always suggest and recommend that the tenant save that rent up. Don't spend it on other things, just in case they do need to pay it later. You want to have that rent saved up. And then lastly, What a tenant can do is, if the landlord's not doing anything, you haven't called code enforcement, you can fix the issues yourself, and then sue the landlord directly for those costs. If they're under $12,500, you can sue them in small claims. If they're more than that, you can sue them in regular civil court. You can also sue a landlord directly for breach of implied warranty of habitability. Again, this is the landlord's legal duty to provide you a habitable unit, and if they're not doing that, you can sue them for it. If it's so bad that you essentially had to leave the unit, you can also sue your landlord for constructive eviction. Next slide. Talk a little bit about best practices. This is both for the landlords and the tenants. There is a duty of good faith and fair dealing. What this means is essentially, a landlord can't fail to make repairs on your unit just because you paid your rent late. Their obligation to keep a habitable unit is in place regardless of you paying the rent, and vice versa. You as a tenant have an obligation to pay rent even if you might not like something that the landlord is doing. So both parties should do what they agreed to do in the lease. So the tenant to pay rent, the landlord to keep up that habitable unit. Obviously things break down, but it's really important to try and keep that relationship going as long as you can. As you move in as a tenant, it's really important to inspect the unit, take pictures of the unit, note any issues when you're moving in, and then similarly, as you're leaving, you want to make sure you're taking pictures, taking videos, noting things that are wrong. You want to, as the tenant, leave the unit pretty much in the state that you found it. We have tenants that live places for 20, 30, 40 years. There is just normal wear and tear that happens. Obviously, if you've lived somewhere for 30 years, the carpet's not going to be as clean as when you moved in. And normal wear and tear depends on how long you've been somewhere. So it's kind of expected, again, if you've lived somewhere 30 years, that the carpet or the appliances are going to be not in the same shape as you found them. However, if you've only lived somewhere for 6 months or a year, that normal wear and tear is going to be much less. If there are issues that a tenant has throughout the tenancy, you want to make sure that you're notifying your landlord in writing, communicating those problems along the way, so that come move-out inspection, it's not a shock to the landlord. If the sink is broken, if the carpet is damaged, you want them to know of any problems as they happen. Like I've mentioned, best to communicate in writing. It's okay if you have verbal conversations with your landlord, but if they have to do with any kind of problems or notifications, best to follow up in writing. This could be a text to your landlord saying, hey, we just had a conversation about my leaky sink. Just wanted to, note it in writing that you said you were going to fix that tomorrow, etc. Paying rent on time. This is obviously the biggest thing that we want our tenants to do. Best to pay your rent by money order or check, so you have that written record. If you do have a tenant who is paying in cash, it is really important if they can get a receipt from the landlord. Most landlords are fine writing a receipt, and then the tenant should keep that receipt for their records as proof that they did pay. Next slide. Okay, we have another hypo. I will read it out, and I think a poll should open for you. So we have Tammy tenant has a rental agreement where she agrees to pay $2,000 in rent. A year into her tenancy, a pipe in her bathroom burst, leaking into the unit. She verbally told her landlord. The landlord immediately repaired the pipe and replaced Tammy's carpets. A month later, Tammy noticed water damage in her walls and started smelling a mildew odor. She didn't inform the landlord and began withholding rent. What best practice should Tammy have done? A, provide initial notice about the pipe bursting in writing, inform the landlord after habitability issues started again, take pictures of the habitability issues, contact code enforcement, or all of the above. And we'll give you guys a minute. Got about half of us responding so far. I'll give it a couple more seconds. Okay, responses are starting to slow, so I think I'll end the poll and share our results. A little bit of a trick question here. The answer is E, all of the above. So the folks that did A or B, you're not wrong. But it does not hurt to do all of these things. So again, anytime there was a problem, landlord fixes something, problem starts again, notify the landlord again. That initial notification doesn't mean that the landlord will just forever know that things might have worsened. So always best to communicate problems with your landlord. I know many of us have tenants who are very, very frustrated because their landlords don't respond. And so they say, what's the point? I email my landlord, I text my landlord, and they don't fix things, so what's the point? And while that is very, very frustrating, for them to then claim defenses down the line or potentially sue their landlord down the line, they do need to keep that written record along the way. So even if it's going to deaf ears, really advise your tenants, push your tenants to keep a written record with their landlord of any problems, even if it's just a text, just so that they can look back and say the landlord was on notice of any problems. Okay, I think we're ready for the next slide.
All right. Now we're gonna discuss the Violence Against Women Act, aka VAWA, specifically the housing protections. Next slide. Public housing agencies, landlords, or managers of covered federally assisted housing have special duties under federal law when renting to tenants who are domestic violence survivors. And in fact, related with respect to all tenants in terms of notifying them of these protections. VAWA is intended to encourage survivors who are receiving housing subsidies to report and seek help for the abuse they're experiencing without fearing eviction. VAWA protects individuals who are applying for or living in federally subsidized housing from being discriminated against because of the things they've suffered under domestic violence, sexual assault, dating violence, or stalking. VAWA, despite its name, applies to people regardless of their sex, gender, identity, or sexual orientation. And again, it only applies to federal housing programs. Next slide. This is just a list of the programs, the housing programs that are covered by VAWA. Some that I frequently encounter are people with Section 8 vouchers, low-income tax credit, housing tax credit units, or public housing. Next slide. VAWA applies to people who are experiencing any of these following types of crime or activity: domestic violence, dating violence, sexual assault, and stalking. And just keep in mind, the domestic violence definition is pretty broad, right? It counts as any felony or misdemeanor crime of violence committed by a current or former spouse or intimate partner, a person with whom the victim shares a child, a person who is or has cohabited with the victim, or a person against whom a victim is protected from acts under this type of act under state and local or domestic violence laws. So it's even broader than the federal statute language itself, because it includes the sorts of activity that are covered. It brings in the state laws. Next slide. Darlene, you're muted. I'm sorry.
Thank you. So generally, a person cannot be denied housing or assistance based solely on criminal activity that is on the basis of or a direct result from their status as a survivor. And so this would be adverse factors that are resulting from the abuse that might lead to, a criminal history. An incident of domestic violence is not a serious or repeated lease violation by the survivor, or does it apply to be a good cause reason for evicting the survivor. There is an exception to this protection, however. Housing providers can still evict and terminate assistance due to an actual or imminent threat to other tenants or employees if the survivor is not evicted. There's a very specific language that defines what that is. An actual and imminent threat consists of a physical danger that is real, would occur within an immediate time frame, and could result in death or serious bodily harm. So in determining if an individual would pose an actual or imminent threat, these factors have to be considered: the duration of the risk, the nature and severity of the potential harm, the likelihood that the potential harm will occur, and the length of time before the potential harm would occur. Eviction should always be used as a last resort. Housing providers have other options that they can perform for survivors, and that includes transferring the survivor to another unit, involving the police to keep the abuser away, and seeking other legal remedies to keep the abuser off the premises. Eviction of the survivor should occur only if there's no other action that can be taken that would reduce or eliminate the threat. Restrictions that are predicated on public safety cannot be based on stereotypes, but must be tailored to particularized concerns about individual residents. One option under VAWA, next slide, is to remove the abuser. And so a public housing authority or a landlord may bifurcate or split a lease to evict a domestic violence abuser while allowing the survivor to stay. The remaining tenant generally has at least 90 calendar days or until the lease expires, with a possible 60-day extension, so that they can establish eligibility for the existing program or for another covered housing program, or to find alternative housing. Keeping in mind, the landlord must follow federal, state, and local law in evicting the abuser. And this would be, more advantageous than obviously, like we've talked about before, as far as eviction of the survivor. Next slide. So under VAWA, survivors have multiple options to document the abuse to request protections under VAWA. And these are, first, survivors can use a self-certification form, and this is under the HUD form number 5382. They can use a police, court, or administrative record. Third, they can use a statement from a third party, or they may provide a statement or other evidence at the housing provider's discretion. So it's available options as far as the documentation under VAWA. And I'm going to turn it back over to Sarah, who will go into notice rights under VAWA.
The next slide, please. Okay, so like Darlene mentioned, next we're going to talk about VAWA notice rights. So many people don't realize or are unaware of their rights under VAWA and what rights they're entitled to under the law. So it's really critical for tenants, for all of us, to understand what these rights are and what rights you have to receive notice. So what the law says is a housing provider must provide a HUD notice and self-certification form to applicants and tenants at the time the applicant is either denied admission or assistance, when they're admitted or given assistance, or with any notification of eviction or assistance termination. All adults in the household have to receive notice, not just the head of household. So everyone needs to receive this notice and self-certification form. Existing tenants need to be provided with notice. This can happen during the annual recertification, during a lease renewal, or any other time if they're not doing these annual recertifications. These forms are available in many languages. They've been made available in 14 different languages. How we see this in our practice come up a lot is that when a tenant receives an eviction notice, so a notice maybe they didn't pay their rent or reached another term of their lease, if they are covered by VAWA, the landlord has to include these forms, these VAWA forms, with the notice to terminate tenancy. If a landlord does not include these notices along with that notice of termination, the notice is invalid. So this is a very big defense to a potential eviction. So it's really important if you have tenants who are covered by VAWA and aren't receiving these forms, refer them to legal aid, get their notices evaluated, and they could potentially have very strong defenses to a pending eviction. Next slide, please. Darlene hinted at emergency transfers. This is another right under VAWA for tenants who are people who have suffered domestic violence or survivors. So this right is a right to an emergency transfer so that the survivor can get into a safe environment. These are really crucial. This is a really crucial right for survivors to make sure that they can find safe and affordable housing. So covered housing providers have to develop emergency transfer plans to coordinate these emergency transfers. So they have to have some kind of system in place to process and work through these emergency transfer requests. A survivor is eligible for an emergency transfer if they've expressly requested the transfer and they reasonably believe that they are threatened with imminent harm from further violence if they remain in their current apartment. Or if the survivor has been sexually assaulted on the premises within 90 days of the request. This 90-day deadline could be extended if the housing provider permits. So if you have a tenant who experienced sexual assault farther than 90 days away, it doesn't mean that this right is automatically gone. It's kind of a case-by-case basis. You could, potentially make a reasonable accommodation request or still reach out to the housing provider and ask for this emergency transfer. Housing providers may process these transfer requests that are even not in writing, so long as the tenant expressly makes the request to transfer. So our overarching theme is in writing is best, but if you have a survivor who orally made this request, it does not mean it's invalid. They just need to expressly say they are requesting this emergency transfer. This kind of transfer does not supersede just regular eligibility for a new unit or other occupancy requirements. So this means that the survivor still needs to be eligible for the covered housing program that they're trying to transfer to. For survivors that are requesting external transfers, into a different building outside of where they're currently living, they still need to apply to that other program. And the emergency transfer plan needs to provide some measures to assist the tenants in that transfer. Next slide. This is obviously a very sensitive subject. We just know that a lot of domestic violence survivors do not come forward, access their rights just due to safety, not wanting to be evicted based on this domestic violence that they've experienced. But the law does come with rights of confidentiality. So it's really important for survivors to know that under VAWA, when they make these requests, that their information will be protected. So what this means is information submitted by survivors under VAWA must be maintained by the housing provider in strict confidence. So housing provider can't allow anyone administering assistance or employees to have access to this confidential information unless it's been explicitly authorized. That confidential information can't be entered into shared databases or disclosed with others, except if it's been consented to in writing by the survivor, if it's required to use in an eviction or termination hearing, or if the law otherwise requires it. But if you don't have one of those three things, then this information has to remain confidential. Next slide, please. If you have a tenant or a survivor who feels like their VAWA rights have been violated, they can file a complaint with HUD. This complaint process has a 1-year deadline, statute of limitations, so you have to file this complaint within 1 year of the right being violated. And so if you have someone who's not sure if they want to file a complaint or if they're not sure their rights have been violated, again, refer them to legal aid or have them just submit a complaint to get in within that year if they're unsure but feel like their rights have been violated. Next slide. Another quick hypo. Tim Tennant is a survivor of domestic violence and wants to assert VAWA protections and request an emergency transfer. True or false? Tim Tennant cannot request an emergency transfer because VAWA only applies to women. Okay, got about half replying so far. Give it another few seconds. Okay, we're slowing down, so I'll end the poll, but overwhelmingly, folks have chosen false, which is correct. Unlike the name implies, VAWA protections are available to all genders. Okay, we can switch to the next slide and I will pass it back to Anna.
Thanks, Sarah. All right, so Sarah and Darlene went over the VAWA protections, which again is a federal law and applies to federal housing. I'm going to start talking about the California laws that protect domestic violence survivors. So these apply to everybody renting in California. Some of the primary laws are the right to have the locks changed, the right to not be evicted for being a victim of DV, the right to break the lease if you are a victim of domestic violence, and sort of the housing provider's general duty to provide reasonably safe housing. Next slide. All right, so tenants have a right to get the landlord to change their locks under certain circumstances. A survivor of DV can demand their landlord change locks, whether or not the abuser is a tenant, but the stand is also a tenant of the unit, but the standard is a little higher. It's a little harder to do if the abuser is also a tenant. If the abuser is a tenant, a survivor must provide a copy of a court order that excludes the abuser from the home and make a request in writing to the landlord for them to change the locks. The court order that excludes the abuser from the home can be a TRO or a protective order, for instance, and it must have been issued within the previous 180 days for this protection to apply. If the abuser is not a tenant, the survivor has to ask the landlord in writing to change the locks and provide a copy of verification of the abuse. This is a little less demanding standard. It can be a copy of a court order or of a police report that just names the other person as an abuser. If the survivor provides the landlord with the request and documentation, and the landlord has 24 hours to change the locks. If the landlord doesn't do that, then the survivor has the right to change the locks themselves. But you will have to give the landlord a copy of the new key. Next slide. People experiencing domestic violence have a right to break a lease in order to get away from DV. They have to notify the landlord in writing that they intend to break the lease and attach proper documentation to verify the abuse. Again, a copy of a restraining order, a protective order, a police report, or documentation by a qualified third party, which, for instance, might be a domestic violence support counselor or something like that. And the documentation must have been issued in the last 180 days. When a survivor provides this notice that they intend to break the lease, they will only be responsible for 14 more days of rent. So even if you're only 2 months into a 12-month lease, if you provide the required documentation and written notice, you're not going to be responsible for the remaining 10 months of rent money. You're only responsible for 2 weeks of it. So it's a much lower burden. Even if the survivor can't pay just those 2 weeks, like that credit hit is so much less than the credit hit from breaking a 12-month lease might otherwise be. Next slide. Victims of domestic violence and related harms are protected from being evicted based on the abuse. This is a defense that a tenant can raise in the eviction lawsuit or even before the lawsuit if they get in, at the notice stage, saying, we're planning to evict you. And it applies whether or not it's available, whether or not the abuser is also a tenant. Again, as with the right to change the locks, this defense is easier to make if the abuser is not also a tenant, but it is still available. Again, the tenant has to provide documentation by a qualified third party, a restraining order, or a police report issued in the last 180 days of the abuse. There is an exception if the landlord says, okay, we won't evict you for this, but you have to not let the abuser back, and the tenant allows the abuser to return, then the tenant can still be evicted for that. Or if the landlord believes that the abuser poses a physical threat to other people on the property. And if the abuser poses a physical threat to other people on the property. All right, next slide. California law also prohibits landlords from evicting or threatening to evict people for calling the police or emergency services. So say someone has a stalker who keeps coming to the unit and the tenant keeps calling the police to make them leave. The landlord issues a notice saying, like, we're terminating your tenancy because you've brought the police here, 7 times in the last year. That's an illegal basis for eviction, and the tenant should assert this defense, because if they reasonably believed they need emergency services, they have a right to get that. Next slide. This is, again, the landlord's general duty to provide safe housing. This isn't DV specific, but of course it's beneficial. Landlords have a general duty to maintain the property in a safe condition. Tenants can request basic improvements like better lighting for the common areas or the parking lots, or putting more durable locks on exterior doors. Landlords who breach their duty to maintain the property in a reasonably safe condition may be subject to civil liability. In other words, they're going to be exposed to a lawsuit where they might lose money. Next slide. All right, hypothetical for everybody. Tammy tenant has a stalker. Oh no, I gave this as an example earlier. Anyway, okay. Tammy tenant has a stalker. She obtained a restraining order from the court. Her stalker continues to harass her, but stays in the common areas of the apartment complex. Tammy frequently contacts the police for help. Her neighbors have complained to the property manager that the police come to the apartments frequently, and the property manager then issues a termination notice based on frequent police activity. True or false, Tammy has a right to be protected from eviction on this basis. All right, I've got a lot of answers already. I'm going to wait another minute just to get some more people. All right, that's pretty good. All right, most of you got this right. True, Tammy is protected from being evicted on this basis. Next slide. Thanks.
Okay, we're going to change gears a bit, and we're going to talk about the California Tenant Protection Act, some updates, and just cause and rent caps. Next slide. For covered properties under the Act, a landlord may not terminate the tenancy without just cause if a tenant has lived in the unit for at least 12 months. Notably, if tenants have been added or have left the unit, just cause protections apply either when everyone has been in the unit for 12 or more months, or when at least one of the tenants has continuously lived there for 24 months. Just cause reasons for termination must be stated in a notice to terminate the tenancy. And there are two types of just cause terminations that we're going to discuss today, which are at fault terminations and no fault just cause reasons. Notably, a tenant may not waive their rights under the California Tenant Protection Act, and any agreement to do so by the tenant is void as contrary to public policy. If the unit is already covered by any local eviction or rent increase regulations, the unit does remain subject to those local regulations, and the statewide law does not remove or replace those extra tenant protections. And a tenancy may not be terminated again unless the landlord has one of the allowable just cause reasons, which must be stated in a written notice terminating the residency. Next slide, please. So first, we're going to discuss at fault just causes, and this is a list of where the tenant is at fault for any one or more of the following reasons. One thing we see quite often is non-payment of rent or lease violations, nuisance on the property, waste, refusal to enter into similar lease agreements, criminal activity on the premises, assigning or subletting a unit, refusing to allow the owner to enter the premises, using the premises for an unlawful purpose, an employee, agent, or licensee's failure to vacate after being terminated from the employment, or failure to vacate after a tenant provides notice. Next slide. But there's also causes that are no fault of the tenants where tenancy can be terminated. And there's some extra protections in the law this year, Tenant Protection Act this year, that close some loopholes that have been created around some of these circumstances. The first one is in respect to again, this is where the tenant has made no fault of their own, but the landlord is choosing to discontinue the tenancy due to one or more of these following reasons. With respect to the owner move-in, this would include a move-in by the actual owner, the spouse, a domestic partner, children, grandchildren, parents, grandparents of the owner of the property. And there's some extra protections to tenants this year with respect to additional information that's required. With an owner move-in, the individuals who are going to move in need to be identified, and there needs to be documentation as far as the tenant now has the right to demand proof of that relationship, and the individual has to reside there within 90 days of that notice and maintain their residency in that unit for 12 months at a minimum. Other protections are in regards to an owner complying with an order to vacate, for instance, regarding habitability. And that would be where we discussed before, let's say there's a code violation that is quite significant, where it's not safe for someone to reside in the unit, and there's been an order to vacate the unit for not being safe to live in. In addition, a landlord may provide a termination of tenancy if they intend to demolish or substantially remodel the unit. And again, this the word is focusing on that substantial remodel. This isn't about like, oh, we want to put new cabinets in the kitchen, or put new countertops in the bathroom. This is in regards to where there needs to be significant work that's going to be done. You're looking at mold removal, remediation, asbestos removal, something that where it would not be feasible to have someone living in the unit when the substantial remodeling or demolition is occurring. And there are some extra protections this year in the Tenant Protection Act that landlord has to give specific information regarding the remodel. They have to provide copies of permits and notice to the tenant as far as what work will be completed. And those new protections went into effect April 1st. An important thing to consider is that a tenant may be entitled to some relocation assistance equal to 1 month's rent for having to move out of the unit. And then also if there's if the tenant receives information that with these extra protections that a family member has not moved in as alleged, or the work has not occurred, then there are rights to the tenant as far as moving back into the unit under the original terms of the lease. So another thing to consider is just the mere expiration of a lease or rental agreement is not does not qualify as a just cause to terminate a tenancy. Next slide, please. And then, of course, we have rent caps. And so for a covered property, landlords cannot increase the rent in any 12-month period by more than 5%, plus the percentage change in the cost of living, or 10%, whichever is lower. And there can't be more than 2 rent increases per 12-month period. Properties exempt from the just cause protections and rent caps include most single-family homes, housing that has been issued a certificate of occupancy in the last 15 years, and also LIHTC properties. And looking at the time, I think we're gonna have Sarah close us out and provide some extra time for questions and such.
Thank you, everybody. So we just threw a lot of information at you. I was looking at the chat while Darlene and Anna were speaking, and it looks like there's been some great questions that Laura has been answering. But if folks have additional questions that they want to ask, feel free to, again, raise your hand now. We have about, I think, 15 minutes or so for additional questions. We want to thank you all for joining. There is a really great big group here. I just want to reiterate that if you have clients or tenants that you're unsure if they have a legal issue or if it's something that Bay Area Legal Aid can help with, please have them reach out to our legal advice line. We have the number again up here on the screen with our hours. As you can imagine, we have a lot of people calling. And so the best way to reach us is just to call right when the line opens at 9:30. If they're not able to reach someone, if they leave a voicemail, I think currently we're getting back to folks within a 24-hour period. But of course, just if you don't reach someone, if you're having trouble reaching us, please just tell them to continue trying to call. We have an office here in downtown San Jose. Folks are welcome to come to our office. But the best and quickest way to reach an attorney for advice is, again, to call this number. So I'll open it up now to questions that folks have, and just want to note that we can't answer any specific legal questions. If you have, here's the tenant I have, here's my situation, what's legal advice, but we can answer just general questions. And then if you have specific questions, give us a call or we can chat offline. And I see in the chat folks asking for copies of the slides, and we will be providing those. I think Sadaka might email them out to everyone after the presentation.
The slides and the recording will be posted on the COC website at the end of this training series. So just be on the lookout, and I will send an email to everyone who has participated when the slides and materials are ready to be posted. And also, I will put in the chat feedback survey for this training. See how you all feel. Please fill it out. And at the end too, the survey should also pop in on your web browser. Again, thank you all for coming to this training, and please unmute yourself and ask questions.
In the chat, someone asked about, is there a limit to an application fee amount? I'm pretty sure it's around $60. People correct me if I'm wrong. There is a maximum, and I think it's around $60.
It's not a dollar maximum, unfortunately. It's $30 in like 1998 adjusted for inflation, which seems to be somewhere between $50 and $60, but I haven't done the math. And someone says in the chat that they just paid $80 for a credit check. I'm just going to point back to, I think the recently updated law on this is that the landlord is required to provide applicants with the receipt for what they paid and itemize like how much the landlord themselves paid for the credit check and like, you know, the man hours and etc. Basically where that money is going. So if you didn't get that, I would ask for it if this was in the recent past. That is, yeah, Civil Code 1950.6. Someone else asked, can rent be increased within the 12-month period if there is a change in the head of household on the lease? That depends, basically. It depends on whether the change in the head of house, like what you mean exactly by head of household. If the people on the lease are the same people, and you're just changing sort of who's in charge, I don't think that would have any impact on the rent cap protections under the Tenant Protection Act. If somebody is being added to the unit, then yes, that affects whether the rent cap protections will apply to them or not.
Any other questions for folks? If not, we all will be back next week and the week after. Happy to answer questions throughout this time. If you think of something later, just reach out to Sadka. In the chat, I see someone's asking, are landlords able to restrict the age of a pet you want to get? I would think no. The restrictions might come in if the landlord has some kind of, you know, credible fear of the pet. And I mean that in if they think the pet is going to potentially harm other tenants. And I don't see how age could really play into that. This would be maybe a case-by-case basis on your specific pet, but I don't see how just a blanket restriction on the age of the pet would make sense. But folks, correct me if I'm wrong.
Someone asked in the chat, can pet rent still be charged if your animal is verified as an emotional support animal? No, you can't be charged pet rent for an animal that you have verified as a medical support. Lisa, you wanna unmute and ask a question? Could you guys hear me? I don't know. Okay, I don't, oh, okay. Lisa says she can't unmute. Lisa, when you are able to unmute, just
I'm trying to hit unmute for you and it's not working. If you're able to put it in the chat, we'll try and answer it, but that's frustrating that you can't unmute. I'm sorry.
I'm seeing a lot of emotional support animal questions. I'm going to reiterate what Laura said. Next week is when we're going to be covering reasonable accommodations.
And then it looks like Lisa's question kind of goes to that. So I think we'll make note of these questions and make sure it's something that we address next week when we talk about the reasonable accommodations, which can include things like these emotional support animal requests.
Yes, we will be sending out the slides. Someone asks, do we recommend any legal aid orgs in Monterey County? I personally do not know anything outside of my own county, so I have no idea.
I worked in Monterey County, so I know the one that I worked at, which is Legal Services for Seniors. They do all kinds of civil legal aid, including housing work, but it is age restricted, so over 60 years. I don't know if you're looking for someone who's under 60, what other orgs there might be. There's kind of a similar organization in Santa Cruz, but I would say Google is the best bet. Or if you'd like to call Legal Services for Seniors, I'm sure they could recommend another org if they can't assist. Yes, CRLA is another one.